if anybody were to go through any of my files at any of these places, this is what you come up with, that this man is honest, this man has integrity, and this man has what it takes to be a leader. And I believe that I have what it takes to lead the judicial service.
Thank you very much. That is preliminary. I will then proceed to give the floor to Honorable Roxanne Nelson Kwame Eche Dapamekbo to ask questions. Honorable member, you are entitled to 3 questions. You may ask up to 3 questions.
Chairman, thank you very much. I'm guided. My Lord, you're welcome.
Thank you very much.
I wish you all the best.
Thank you.
And thank you. But let me touch on a matter that is out there. What would you say to those who suggest that your nomination by the president was a reward for your holding in his favor in the 2013 election petition? It's some debate out there.
Well, I don't know, but I actually will be disappointed if my only qualification for the Chief Justice nomination is because I voted for the president in 2013. But I mean, that is on a lighter note, but I think I qualify for the position. As I said, I have been a Supreme Court judge for the past 17 years. I would not be presumptuous to say I am the best qualified person in the Supreme Court. No, I would say that. But I've been at the Supreme Court for the past 17 years. The person who has served nearest to me has been there for 10 years, meaning I was at the Supreme Court in 2008. The next person came there in 2015. The others are from 2019 and then 2020. So I think I qualify for the position. And let me add something. I was actually, if you look at my CV and if you follow the trajectory of my career, I was actually admitted, I actually was made a circuit court judge by Chairman Rawlings. Then I was promoted in 2000, and I was sworn in together with Sergeant Jamefe. I was sworn in by the then Vice President, President Mills. Then I was elevated to the Court of Appeal by President Kufuor. Then to the Supreme Court by President Kufuor. So if, that was 2008. So if 17 years later, another president deems it fit to eliminate me to the position of a Chief Justice, I think I cut across all political boundaries. I don't think that because from Rawlings, Mills, Kufuor, and then Mahama, I think I deserve the position, that's why. But as I said, the president might have personal reasons. I don't know that.
Very grateful.
Any further question?
Yes, my Lord, you have a very rich and expansive CV. I see that you've done, as part of your work as a juristic officer, you have also worked extensively in election and election-related matters, chaired a lot of committees. Now, the argument is out there regarding the duration that presidential election challenges take, all the 2 or 3 that we've had so far. Will you consider, if you get the approval of this House, will you consider introducing reforms such that, for instance, a challenge can be determined before inauguration on the 7th? Will you consider that? That is between the 7th of December and the 6th of January. Will you produce?
Thank you, Honorable Chair. Thank you, Honorable Chair. You see, as part of as you said, I have been a member of the Election Management Committee of the Judicial Service since 2010. And then I became its chair in 2020. As a part of our engagements last year, we had a lot of stakeholder engagements with IPAC. We had stakeholder engagements with the CDD, CODEO, that is CSOs, and then the Peace Council. The main theme of these meetings was the fact that in 2013, the election petition lasted for almost 8 months. The final decision came on the 29th of August. Essentially, I'm the only surviving member of that panel. Everybody else has retired. The final decision came on the 29th of August because one of the first drawbacks was we spent almost 1.5 months discussing whether to even allow the NDC as a party to join the action. In the long run, at the end of the day, by a majority of 6-3, NDC was joined to the action. It was one of the greatest mistakes we made in that particular trial. And that was one of the first things we touched on after the trial. We went into a conclave and came up with a decision that, no, there was no need to join any other party. So CI 99 came up, and that was when we decided that the trial and everything could be done within 42 days. So discussions went on, and we agreed on 42 days maximum for presidential election petitions. And so in 2020, when there was an election petition, it was a straight fight between JDM and then Akufo-Addo at the time, and then the EC. And it took 42 days to deal with that election petition. But we know that Kenya does theirs within 21 days. The only time America faced an election petition, that was between Al Gore and Bush in 2000. The election petition, whatever it was, ended with the declaration of the new president before the election. So at most of these forums or fora where we discussed the elections in Ghana, we came to the conclusion that it should be possible to have the election petition concluded before the 7th of January, the inauguration day. And the first suggestion that came, which we think was a master's stroke. Was that we should have the elections on the 7th or the 8th of November. If we have the elections on the 7th or the 8th of November, by the 10th, the results would have been declared. If we have the results declared on the 10th of November, we have 20 more days before even November ends. Then 31 days of December, then 6 days of January, making a total of 57 days. Assuming we want to stick to even the 42-day window provided by CI 99, we can have the election petition filed, responded to, and everything tried 57 days. That is number one. In addition to that, we can have, lawyers say that every originating motion or originating process has to be served personally on the defendant or respondent. But we all know that in this day and age, every email saying that you file a petition and it takes 7 days to get to the respondent, using the electronic mail, we can reduce the number of days to, let's say, 3 days. So a process that is filed, if it is served electronically, even the originating process can be filed and served electronically within 3 days. Instead of waiting for, let's say, 1 week for the response, we can reduce the number of pleadings would have closed. CMC, court management conference would have gone through, issues would have been settled, and then the trial will begin. And a trial like that, we can say it should take no more than 2 weeks. And once 2 weeks are there, we say judgment should be given within 1 week on the release of the results. Meanwhile, at this point in time, during December, we have a lot of holidays. But under the fiat of the Chief Justice, the registries can be made to stay open so that processes can be filed, served, exchanged, everything can be done in such a way that we can have all these things done before the end of January, so that by 7th of January, Inauguration Day, we will have our president who will take the sword and swear to his people and be able to say, because we all know in 2013, for 8 months, the president-elect was performing his constitutional duty all right, but he wasn't too sure whether he was going to be chalked off or replaced or what. Even though the 2020 election petition also lasted for only 42 days, it lasted beyond the inauguration. So these are things that we have discussed. And we shall need the input of Parliament when it comes to LIs and CIs to be prepared. So this is what I intend to pursue so that we can have our election petitions, if any, in future. And I'm sure there will be, and before the inauguration day. Thank you, Mr. Chairman.
Thank you very much. Do you have any further question?
Mr. Chairman, thank you. That is so. My Lord, I appear to be the Lone Ranger in this matter. The welfare of the judges at the magisterial level is so dear to me. But I see a disparity in the welfare, in the service of office and conditions of office for what you term professional magistrates, that's lawyer turned magistrates, and the career magistrates. And they do a lot of work, the career magistrates. In some cases, they do relieving in 2 or 3 other district courts within their jurisdiction. So the question, introducing the career magistrate program to absorb young men who are interested. Yes, reintroduce, because it will be a very heavy source of personnel. And also reforming them in such a way that they will have the opportunity of rising through the ranks to the level. Because recently you just elevated.
Honorable member, I think
finish.
you have
Mr.
asked
Chairman.
your question.
No, Mr. Chairman.
You see, today I said we'll go by the rules. A questioner is not supposed to run commentary. You don't run argument. The foundation cannot be too long. So,
Chairman, I'm guided. Thank you. So, CJ nominee, will you consider reforming the courses, the career magistrate program in such a way that they will have the opportunity of rising through the ranks and getting to the highest level? Because they do a lot of work as the same as the professional magistrates. Presently, you have about 75 openings at the magisterial level. You just elevated some from the circuit to the high court. Naturally, you will elevate the district judges to the circuit court.
Thank you, Mr. Chairman. In the years gone by, when we started practicing, we had the grade 2 magistrates and the grade 1 magistrates. And the grade 2 magistrates were actually not trained lawyers. Most of them were social welfare workers, retired teachers, and the rest. They were grade 2 magistrates. And then lawyers who had the bench, but were not 3 years, also had to work as grade 2 magistrates. Her Ladyship, Justice Avril Lovelace Johnson, was a grade 2 magistrate in Chebi. I appeared before her when I was a lawyer with IRS in Koforidua. I used to appear before her. But when lawyers get to 3 years, lawyers who had joined the bench got to 3 years, automatically they became grade 1 magistrates. But with the grade 2 magistrates, the original ones, they never had the chance to go beyond grade 2 magistrate. They couldn't join the bench at any level because they were not lawyers. That was the situation of things until sometime, I think in the 90s, the whole concept of grade 2 magistrate was abolished, leaving only professional magistrates, that's lawyers who were magistrates. But then, around the 2000s, the millennium era, this concept of career magistrate was reintroduced. This time they were not called grade 2 magistrates, but they were called career magistrates. But they were doing the same thing. And this time, the judiciary went one step further. whilst with the grade 2 magistrates, they were just social welfare persons who had retired or been drafted to become magistrates. With the career magistrates, these were even, they could be even as young as 30 years. In fact, they were the very first ones were actually workers with the judicial service who were drafted to undertake 1 year or 2 year course at the law school. So they took 2 year courses and then they were made career magistrates. But they are not lawyers. So their career path carries them only to the chief magistrate level. And that was it. It doesn't matter how long you stay there, you can get to a chief magistracy, and then that will be the end. But we still maintained the 3 years for professional magistrates. So what then became the order of the day is that these lawyers, these career magistrates, then opted to go and read law. And once they went to read law, then they could transition to become professional magistrates. But here was the problem. You find somebody who has been a career magistrate for, let's say, 7 years, 8 years, 9 years, 10 years. Now he goes to the law school, he transitions to become, he's a lawyer now. And because he hasn't spent 3 years, he has to remain on the career magistrate level until he becomes 3 years. He gets to 3 years. Even though he might be more experienced than somebody who has left the law school and, been practicing for the past 3 years. So there was a problem. And then again, I know, for example, in the army, if you go through the rank of, let's say, the junior ranks, the furthest you can go is maybe chief warrant officer. But in the army, you have a warrant officer who, because of longevity, maybe even be receiving a salary higher than that of a captain at a senior officer level. But with the career magistrates, it doesn't matter how long you stay as a career magistrate. You cannot run an incremental that will make you overtake a professional magistrate, somebody who has joined just this year. All these were problems but as your honorable member was saying, only about a month or so ago, we had a send-off party for a couple of our retired career magistrates. And it was when their CVs, their citations were being read that we realized that we really need them. Because these are the people who are prepared to go to the nooks and crannies of the country. Maybe you are a magician, maybe you have been following the judicial service. But the vacancy at the district court is 116 at the district court. We are not getting lawyers to join at the magistracy, at the district court. Most of them want to come to the circuit court and to the high court. So with the current elevation of some circuit court judges to the high court and the district court to the circuit court, we are going to have an opening for 116. And I can assure you, we are not going to get, no matter how often, how much we advertise, we're not going to get lawyers to come and fill these vacancies. So it is my project that I will be discussing with the Judicial Council, the reintroduction of not only the reintroduction of the career magistrates, but we should be able to have a proper remuneration regime for them. So that those who come can stay. And then, again, it should be possible that there should be a law that makes it possible for somebody who has been a career magistrate for a certain number of years, if he becomes a lawyer, he doesn't need to wait for another 3 years to become a professional magistrate. There should be a smooth transition. This is a project that I intend to pursue.
Thank you very much. I will then proceed to give the floor to Honorable Mahama Shaibu.
Thank you.
You are entitled to 3 questions. Strictly questions. I can assure you, my Lord, that every member of this committee may want to exhaust the 3 questions. So, strictly questions, no comment. And non-members of the committee, I plead with you to perpetually remain silent.
Chairman, let me thank you very much. My Lord, congratulations. Chairman has cautioned. But, my Lord, cost of litigation by the day has become very expensive. Legal Aid Commission came in as a stopgap. Unfortunately, they have in courts and represented litigants. Would you consider fashioning out a very simple procedure which can take care of unrepresented litigants? Thank you.
Thank you very much, Honorable Chair. The legal aid is an orphan. The legal aid board is an orphan, like the prison service. Now the prison service, they are getting some parents, but the legal aid remains in the doldrums. It is true that cost of litigation is now very high, and it's become very, very high. Higher as a result of the delays that are occasioned in the courts, so that even small, minor offenses in the criminal realm, small claims so litigation is now very expensive. And when you look at the persons who patronize the legal aid, you realize that, but for the fact that they don't have the means, they wouldn't go there. Are very much under-resourced. So it is something that I have discussed since I started acting. I have discussed with the Attorney General, and we are trying to find a way of resourcing the legal aid. As a matter of fact, with time, in the long term, we are thinking of even mobile courts. I had the 24-hour idea, economy idea from the Judicial Service, because we have planned for some time now to introduce courts around the clock so that we can have night courts. And then, see, all these are supposed to augment the legal aid situation. If there are courts around to take care of cases, definitely the cost of litigation will go down. So apart from asking for more resources, which I have discussed with the Attorney General, we are thinking so much about other things like having night courts, weekend courts. Already we have weekend courts to take care of electricity and other things. So once we do that, we hope that, and then to cap it all, the ADR, ADR is something, an avenue that we want to highlight. Already we have court-connected ADRs, and then we have set aside weeks, 1 week in every term to have ADR sensitization. But people are still not sensitized enough to resort to ADR in some of their claims. So we have a combination of plans to get rid of, to restore the legal aid and also reduce the cost of litigation. Thank you.
Thank you very much. I recognize a supplementary question from Honorable Mahama Ayariga, the leader of the House. You have the floor.
Thank you. So, my Lord, do you have your commitment that your court will now say 24 hours when you become Chief Justice? Judiciary at 24 hours.
I said we are exploring. Already we have,
we want to pin you down to a specific commitment to this committee that the courts will explore and will sit 24 hours and provide opportunities to citizens to pursue justice 24 hours.
Well, it is possible, but for now, we have some courts that have morning shifts and afternoon shifts. At least for now, we have that one. And we have some courts that sit over the weekends. So it is now left to us to, so we can say we have a 16-hour economy.
Kumasi, Tamale, and Cape Coast. This for some time now has not been working, or it has been suspended. Would you consider that Accra is not Ghana and that many regions still will have to travel to Accra to the Court of Appeal? Would you consider reinstating and possibly expanding that service to all regions of this country? Thank you.
Thank you, Mr. Chairman. I think with all due respect to the questioner, I think the question is not factually correct. Yes, we used to have Court of Appeal sitting in certain regional capitals that are not where we don't have them now. But it is not true that all the other regions have been suspended. No. Now we have a Court of Appeal in Accra, as usual. We have a Court of Appeal in Kumasi, where we have accommodation. So they are residents there. The judges, there are 10 judges of the Court of Appeal who are in Kumasi, resident there, dealing with cases in the Ashanti region, Brong Ahafo, and the north. We have 5 dedicated Court of Appeal judges for Eastern and Volta regions. I mean dedicated in the sense that they are assigned to only the Court of cases from Eastern and Volta regions. So the Court of Appeal sits in Koforidua. Then a Court of Appeal sits in Sekondi to take care of Central and Western regions, and then the Western North. So we have at least 4 courts of appeal. That is Accra, Kumasi, Koforidua, and Sekondi. These are the 4 places that we have our cases. But whilst because there's accommodation for the judges in Kumasi, they are resident there. The dedicated 5 for Eastern and Volta are living in Accra, but they go to Koforidua 1 week in a month. 1 week in a month. They will go and sit there 1 week in a month. Then those who are for Sekondi also go to Sekondi and deal with cases 1 week in a month. Now, Tamale and the North don't have resident judges there, but they are also served by the judges in Kumasi. But you see, because of distance and then even costs, any time the 5-member committee, judges, the panels goes to Kumasi, goes to Sekondi, the service spends 38,500 cedis or 40,000 cedis on them in terms of hotel accommodation, transportation, and all other logistics. Koforidua, if the 5-member go, it's the same thing, around 40,000 cedis. But you see, going from here to Koforidua is so easy, even though it is risky and inconvenient. It is so short. The Kumasi people found it very difficult to go to Tamale, where they would meet the judges. So they were doing virtual hearing. The virtual hearing was started at the time of COVID, and we realized that it is a very good way of doing things. So Kumasi and the North were communicating only by virtual hearing. And then, but when I started acting, I realized that the virtual hearing was not very convenient because of the interconnectivity. There were breaks in transmission and other things. So I actually spoke to the Judicial Council. We went to see the Minister for Communications, that is Honorable Sam George. And now we have the interconnectivity is so good that even now, we don't go to second year again. We do virtual hearing of appeals for second year. So now instead of incurring 40,000 cedis in a month, we do virtual hearing. So it is something that the lawyers are very, very happy about. For now, the judges stay in Accra, and then the parties meet in Koforidua. So even if the lawyers in the case are in Accra, they still have to go to Secondary to take part in the virtual hearing. Now, what we are aiming at is a situation where we can have persons, for example, Koforidua and Ho. We are trying to get to a situation where lawyers will not go from Koforidua, Ho to Koforidua, but they can also have a hearing whilst they are in Ho, so that the judges will be in Accra, the parties could be in, one of the parties could be in Koforidua, another party will be in Ho, or Cape Coast lawyers can sit in Cape Coast and listen in and take part in it. That is a long-term project, but for now, the regional capitals are taken care of by way of virtual hearing.
It's getting into virtual stuff. So let's move on to empaneling of judges at the Supreme Court. First of all, what goes into the thinking when you're empaneling judges? And given that the human element of it raises some questions, would you consider looking at an automated system of empaneling judges at the Supreme Court? Thank you.
Yes, my lord.
Thank you, Honorable Chair. Empaneling creates a lot of anxieties among people. There are lots and lots of people, suspicions about for judge shopping, persons who are, some judges are not empaneled and other things. I think to get rid of such suspicions, we should be able to call that those who know about AI tells me that if you are able to feed the computer or AI with information about judges, their philosophies and everything, the AI should be able to do empaneling based upon the things that we have fed it with. But, and I think it is done elsewhere, so we can try it. But what actually goes into the used to go, I wouldn't be able to say for some time now what, but when I joined the bench, when I joined the Supreme Court bench, we were about 16. And then when at the Supreme Court, we know everything is based upon seniority. We have persons we refer to as seniors. Then we have the middle, and we find the juniors. There is no derogatory. None of the words is complimentary or derogatory. It only shows when a person was appointed. So I will be the most senior. It doesn't mean I'm the best. Somebody may be the most junior because he was appointed to the Supreme Court only yesterday. But that is how we had this classification. So any case, we had the seniors. So any case that we wanted to empanel, you find one senior. Since we sit in panels of 5, we have a senior, we have 2 middle, and 2 juniors. And that makes a panel. And it was done randomly. There were situations where if we are sitting in 7 and we want to believe that this is a matter that we should get the seniors to sit on, then it is that can also be done. I remember in the 2013 election petition, the empaneling was done in such a way that the Chief Justice opted not to sit on it. Justice Datiba had only 4 months to go on retirement. And since we were not too sure how long the whole trial was going to take, he opted out. Then it was number 1, number 2, number 3, number 2, up to number 9. So it wasn't like somebody had been handpicked from somewhere because of this particular reason or the other to do it. So empaneling is normally done randomly, or it follows certain patterns. But because of the anxiety it creates among people, the suspicions, or people feel it's not transparent, I would not, I think we should be able to consider AI empaneling. But in our part of the world where a person can decide not to sit just about 2 or 3 hours to time because the wife is being taken to the hospital or the father has just died, it means AI will find it difficult to replace such a person. Maybe AI should be told that, okay, instead of 5, set aside 6. So when somebody opts out, you can bring the 6th person in. So AI will be a very good thing for empaneling. Thank you very much.
Yes, Honorable Shaibu, your very last question.
Yeah, exceedingly grateful. Exceedingly grateful, Chairman. I see my Lord has veered into AI. Can we apply AI again or any other method? Backlog of cases and then delays. What concrete steps and time-bound steps would you want to employ to deal with backlog of cases that are hanging and speedy trials? Thank you.
Thank you, Honorable Chair. I think to tackle the backlog, to find a way of clearing the backlog, we must first identify what causes the backlog and then the delays. In the first place, litigation, courtroom litigation the volume has increased, whether we like it or not. Now, people litigate practically over everything. In the years gone by, I'm sure if you took my picture and you displayed it in your newspaper. And so I'll be very, very happy if somebody came and, Daddy, I saw your picture somewhere. I mean, I will see it as even you promoting me. But I'm certain that if you displayed my picture in your anywhere else, maybe even in your house, and without my permission, I will sue you. So now people sue practically over everything. Intellectual property and everything. So the courts are inundated. That is number one. We've tried to solve that problem by opening more courts. But the more courts that are opened, the more the litigation comes up. Some time ago, we had courts up to Medina. From Medina, you could only go to another court on the mountains. Then we realized that we have to have a court at Adenta to take care of that enclave. Now, courts in Adenta have more cases than courts in the law court complex. The threshold for every court should be about 250 cases. At the last count, the High Court 1 in Adenta had 849 cases for one court. So the cases are many. There are more cases. So it doesn't matter how hard you work. You find you deal with one case and 2 more cases are added. Then we have situations which I will refer to as, institutional. CI 47 was actually passed in 2004. Those of us who were practicing using the older version of the rules, that was LN 140A of 1948 or 1950, 1960, 1954, LN 140A of 1954. When we was referring to the White Book of London, of England, which had undergone several editions. But we still had our LN 140 of 1954. By the time we had the CI in 2 dead at birth, it was outmoded at birth. So we have rules in the CI 47 which make it impossible for us to move forward. In this day and age of electronic e-service and everything, we still say that when a person issues a writ, it has to be served within 8 days. Now we have the Electronic Act, which makes it possible for you to do a service electronically. But the rules insist that as far as the originating process is concerned, it has to be served personally. So in this day and age of when everybody fears for his security, we still have bailiffs going around serving processes. So if we improved the rules, we have situations where applications that are filed, applications are filed, and they stall proceedings in the trial courts. All these things are catered for by the rules. So if we are able to review the rules, and that is one of the things that I intend to do, to engage the Rules Committee, the Attorney General's Department, the Attorney General, not Attorney General's Department. I will be on his neck, and then I'm not going to kill him. I'm not going to kill him. I'll be on his neck, and then with the Rules Committee, so that we should be able to amend the rules to make it user-friendly, to take care of the technicalities so that trials can be sped up. As for the cases that are already in the back, that have been clogged, what we can do is that we should be able to track. Now we have a monitoring team, which I'm going to reinforce, that goes about tracking backlog cases that are locked up, and then we will see what we should be able to do about it. This is not to say that there are no human elements in this. Lawyers play all kinds of games to have cases delayed. They play all kinds of games to have cases adjourned. I remember when I was appointed a Supreme Court judge, they were surprised that we could grant adjournments on the ground of somebody's wife. And because a lawyer says, my wife is being taken to the hospital. The judge asked us, are you a doctor? If your wife is going to deliver, you are the doctor, you don't need to be there. You have to come to court. And that is their system. But here, you cannot really tell. So we see there's a human element to this. But we are going to work on all these so that we can have a reduction in the backlog of cases. Thank you, Mr. Chairman.
Thank you so much, my Lord, the Acting Chief Justice, and the nominee before us. We have 6 more members to ask you a question. Therefore, we will plead that the brevity rules that apply to members would apply to you, mutatis mutandis. So I will call on Honorable Haji Aladi to ask you a question.
Thank you, Chairman. Chairman, let me take the opportunity to congratulate my brother on his being nominated. From your narration, you have clearly stated that you've come a long way through so many governments, presidents, vice presidents, and what have you. That is actually a basket full of a lot of experience, and your CV tells it all. However, although you are acting, you are now going to be the substantive, inshallah. My question is, as Chief Justice, you will preside over a Supreme Court with diverse personalities and differing judicial philosophies. How will you foster collegiality and prevent personal disagreements from undermining the administration of justice? Thank you.
Thank you, Honorable Chair. Well, Honorable Chair, by its nature, the Supreme Court is collegial. when we say collegial, we mean unlike the, let's say, district court, the circuit court, and the high court. We sit in colleges, we sit in panels of more than one. So, and then we take decisions together. There is no, every judgment that is delivered that you read about, even though it comes under the hand of one judge, you can be sure that it has been decided by the panel members. Unless there is a dissenting opinion, it is the opinion of the judges. So that is why we say it's collegial. We go into a college, we call a conclave, and then we come up with decisions. You are right. I come from Gozo. The person who is now the president of the court comes from Navrongo. We have somebody from Wa. I went to the best secondary school in Ghana, Korongo Duma Secondary School. Somebody went to a one of us went to a school which is no longer even in existence. Sir Dennis went to a school which at the time was a mixed school. Now it's a girls' school. Achimamai Secondary School has now become a Fiakobi Girls' Secondary School. So he doesn't even know whether he's an old student or... So...
My lord, he's still an old student. And the school is still in existence.
And then there is this Wa man who went to school at Koforidia, the town of the flowers. You see, so you are right. We come from different backgrounds, different schools, different philosophies. Some of us, I mean, a couple of us, about 3 or 4 of us, started from 2 of us started from the magistracy. Her Ladyship, Avril Lovelace Johnson, started from grade 2. Sergeant Jamefe started from the Regional Tribunal. So both below the circuit court where I started. And then there were some of us who joined at the Court of Appeal, like Sir Dennis. Justice Puaman joined at the Supreme Court. Justice Yodi Kulendis joined at the Supreme Court. We have persons who have come from the academia, like Professor Mensah. So we have different philosophies. This is the Supreme Court. And so when you have all these people with different backgrounds having to come together and then agree on something, even with all due respect, you see how lawyers agree or disagree. The little that we saw from the disagree on the rules, the standing orders, it shows that once we come from different backgrounds, we will have different approaches to things. It could be our strength, but it could be a weakness. As a Chief Justice, your ability to harness all these into something concrete, that is what leadership is about. That is what you should, if you are able to do this, and you should be able to discuss things formally and informally before things escalate. You should be able to do things. Even empaneling can create problems among you when somebody feels that this man is not being empaneled I wasn't empaneled for close to 1 year, even though I was the number 2 after the Chief Justice. I wasn't empaneled. It can create problems. But as a leader, you should be able to manage all this. And then you should be able to manage all this. And even though I'm talking about collegiality and then the need to have a consensus, that should not be the final thing. You should be able to encourage parties, judges, to air their views. Dissent should be encouraged. It is always better to have a consensus on everything. But if you can't have a consensus, you should be able to, if somebody says, I'm going to write a dissenting opinion, you should be able to write a dissenting opinion. You should be able to encourage the person to write a dissenting opinion. It is a way of fostering unity amongst yourselves. And fortunately, again, having been here for so long and having been here, having dealt with all the members of the Supreme Court bench now, I happen to have personal relationship with every one of them. Every one of them. Those who used to appear before me when I was a High Court judge, like Justice Dorothy Kulendi, Justice Poaman, they used to appear before me when I was a High Court judge. Justice Dennis used to appear before me when I was Circuit Court judge, and he was a lawyer in Kumasi. And then Justice Ajay Frumpong was a junior to my very, 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 very good friend called O2SL, who has passed on. So when I was even sitting as a High Court judge in Kumasi, he was appearing before me. So I have this relationship with all these judges. That makes it easier for me to be able to bring them all together. So I will be able to do that. Thank you.
Thank you, Honorable Haji Aladi. You have a further question?
Yes, please, Mr. Chairman.
Please do.
Mr. Chairman, there is a very big issue that is worrying a lot of us when it comes to getting maybe people who are brought before the courts so that the judges can handle them very fast. Cases are not taken up very fast. So because of that, you find our prisons choked with a lot of people, some even just because they have stolen a bunch of banana on remand. You simply can't understand. And if you look at them, when people show you such pictures, it's horrifying. Will you consider ensuring that we have at least these community courts, the tribunals, working very seriously, and you applying the 24-hour economy as you have said earlier on, so that such people can be given community kind of punishment just to deter them, rather than pushing everybody to the prisons. Because recently, just 3 days ago, just 3 days ago, I got a message that someone went to court and then was told that the judge had put to bed, so she was not in court. Now, when is she going to come out, let alone to look at it? And I don't know whether it will be passed on to another judge or that case has to wait. So will you consider ensuring that the tribunals come up basically at all the best places that you can think of, so that such cases would be handled or fast-tracked? Thank you.
Yes, my Lord, your response.
It looks like you are speaking the language of my wife. My wife has maybe engaged you to ask questions about the prison service. This is something that I know about, because as I said, I was a prison officer. And since my wife is also there, I know. For example, I am told that the inmate situation in Nsawam prisons was built, the capacity for Nsawam prisons is 851. As of today, they are 3,562. A variance of 2,711. Kumasi male prisons was built for 416 persons. As of today, there are 1,727. And this is replicated all over. The prisons are choked. The prisons are choked. Remand prisoners, I mean, it is a bother. And one of the causes of the prisons getting choked is people being remanded, and sometimes indiscriminately. That is why, and then the minor offenses who shouldn't be there, but they are there. So I think that it was particularly for these minor offenders that the Justice for All program was introduced. And for some time now, maybe because of the turbulence, this year, they have not actually even sat. It is something that I want to reignite, revamp it, so that we can have the Justice for All back on the road, so that we can get rid of some of these persons. But apart from saying this, I also want to say that, Honorable, there are some people in the prisons who have been granted bail, actually. They have been granted bail, but they are still there because they can't meet the bail conditions. And not that the bail conditions are too high. Sometimes they are too high. But in most cases, they are not. In so many cases, they are not. And so you find somebody in prison, somebody on remand, who has been on remand for 5 years, 3 years, 4 years, 5 years, and those of us outside will say, hey, if this man had even pleaded guilty and he had been convicted, he would have spent only 3 years. But because he pleaded not guilty, he's on remand, and his case is not being tried, and he has spent 5 years. But that is not the fault of the judge. If you appear before the judge and you say you are not guilty, you are not guilty. The judge says you are released on bail. But there are some people, unless you say they should sign their own bail bond, they can't get anybody to come and bail them. Unless you release them on their own self-recognizance, they will not get anybody to come and bail them. I mean, there are some of them, and as a judge, we have conditions to grant bail. I'm releasing on bail, is he likely to come and stand trial? The person who is making efforts to run away because he has gone to see some foreign embassies to seek asylum, he's trying to run away already. The man, and so if a judge decides that, no, a person like that, I'm not going to grant to bail, it doesn't matter the offense that the person has committed. The judge may not grant bail, but even if the judge wants to grant bail, he will not give you bail on self-recognizance. So persons like that, they will not get people to stand surety for them, and they will be there. Who shouldn't be there? There are also some people who are there because they have to be there. And honorable, we are always talking about a bunch of plantains, a crate of eggs. My mother is a Catholic, was a Catholic. I always tell this story. My mother was a Catholic. And you know, this old lady, priest, was a white person. So at the end of the year, my mother wants to go and then harvest a particular plantain that he has nurtured over the year. My mother was going to the farm every morning with a bent back. This young man was sitting under the shady tree. In our place, we call it in Kwankwaниase, playing draft. Every day, my mother passed by him to go to the farm. Now, 1 year on, it is time for harvest. My mother wants to go and harvest the plantain to come and give to the reverend minister, the white priest, who speaks Latin. And then this young man has gone there. And you know, when they go there, they don't cut the plantain. They move it from the top. So my mother will walk all the way to the place before realizing that the plantain has been harvested. We sit in Accra here. When a magistrate at Gosu decides to send the boy to prison for 3 years, we sit in Accra here and say the man stole only a bunch of plantains. Do you know what it means what the bunch of plantain means to my mother? It's like stealing your car. You see? So, I mean, there are so many reasons. The magistrates and the judge, they are trained. They have this, the sentencing guidelines. They have them. But sometimes they have to go beyond it. In my youthful days, I gave somebody 70 years. Atayi, I gave him 70 years. And what I told myself was that if Atayi was given 30 years and he comes back, my family will be the first family he will attack. So by the time he comes back after 70 years, I'll be dead and gone. So you see, then we are thinking about community service. Yes, there are some people who, if you give 3 years, 4 years, touch wood, if I am convicted and sentenced to 4 years in prison at Nsawam, I may not eat prison food for even a day. I will have some people bring food to me. So if you want to make me feel the prison punishment, prison sentence, then maybe you should order me to go and do community service. Maybe around the place where I stole, around the court, that they'll see me. Because punishments are not only for the person, the victim, or the person being punished, but to deter other people. So community sentences should be introduced. But that one is in your bosom. It's a law. That one will have to be taken up by you. Another way of decongesting the prisons is through the parole system. people should be able to go out on parole for exhibiting good conduct or whatever. So if the parole system is introduced, I'm certain we can reduce the numbers in the prisons considerably. But, you know, parole system, you cannot do that without tackling the social welfare angle of the parole system. You have to beef up, because I know in some jurisdictions, when a parolee or a person who has been granted parole may not even be able to go beyond a certain distance because he has a tag that gives AI alarm to somebody. We don't even have these things here. So, Honorable, we are at it. We will play our part by reducing our pension for imprisoning people. We will curb that pension of giving long sentences. I'll talk to my people, because any long sentence person you send to my wife, I get a knock. You allow these people to come here, and they are disturbing me. So, Honorable, that is what we are going to do. Thank you.
Thank you very much. Honorable Ladi, do you have a supplementary question, or you want to ask your last question?
Thank you, Chairman. I want to ask my last question.
Thank you very much. Proceed to ask your last question.
Mr. Nominee, during your presentation, you mentioned places where we can find courts of appeal. Unfortunately, I sat really feeling very bad, because I would say I come from the northern sector. And I have continuously heard my people crying when they have any case that needs to go to the appeal courts. They would have to travel as far as to either Kumasi or Accra. I have listened to you carefully and heard you talk about infrastructure and the way monies have to be spent, which is quite a difficult one. Will you consider putting up at least one with all the amenities that are needed to take care of the 5 regions of the north, to ease problems of our people having to travel these distances?
Yes.
Honorable Chair, Honorable Chair, it is possible, it is feasible. We have done it before. We have done it before. You see, I know how sentimental people feel about such things. When I started acting, I got a letter from a community, and they said they wanted, it was written so beautifully, they wanted a district court. So I gave it to the court's services manager to advise me. And you know what? He came up with the fact that the community they are talking about, they are 500 people. 500 people. And then he mentioned the various courts that are close by. And we found that almost all those courts have cases no more than 10 a day. Sometimes the whole week. It is not, when we tried the Court of Appeal in Tamale, we realized that all the cases could be heard within a matter of 2 months. All the cases. So it is just not feasible having 5 judges stationed at Tamale to take care of the north. This is not just because the number of cases that come from the various regions put together is not up to much. So, to prevent this situation where lawyers and parties will be coming to Kumasi or Accra, that is why we are introducing the virtual, so that they will be meeting in Tamale. The lawyers don't need to, with virtual hearing, the lawyers don't need to move at all. They have to be in Tamale. So, as I said, if you have a case which is being handled by a lawyer from Kumasi, for now, the lawyer will have to travel to Tamale to go and be in the Tamale courtroom where the virtual takes place. But as I said, we are working at it. In a matter of time, we have find ourselves in a situation where some of the parties and the lawyers can be in Tamale courtroom, whilst some other lawyers will be in Kumasi and they'll be hearing cases. This is done. When international arbitration takes place, people hardly travel from here to London for international arbitration. They do virtual hearing. So that is what, if it becomes necessary for us to station judges permanently in Tamale like we have done in Kumasi, we will do that. But Honorable, you have to help us get accommodation for them.
Thank you, Honorable Ade. You have exhausted your 3 questions. On this note, honorable members, our revered guests, it is in the interest of all of us to take 20 minutes health break. Well, Hajia, you have the floor for 1 second.
Thank you very much, Chairman. So, my brother, I wish you all the best. When my colleagues were leaving, you would have heard them. It's normal of me to say, I wish you all the best. May the Almighty Allah guide and protect you.
Thank you.
So that you will be able to do your work as expected.
Thank you.
And to the best of your knowledge and to the development and progress of Ghana.
Thank you so much.
Thank you very much. We shall resume our seats exactly 10 minutes after 5 o'clock.